Okay, I'm going to go ahead and get started. And welcome to the administrative regulations. They're the operating document that we use to pretty much follow for everything. Now we have Cook County people here and we have non-Cook County people here. Things are a little different because you have a union contract which covers some of the things in the regulations, but I will still touch on some things in section 4 that apply to union and non-union employees. So we can just things that I wanted to point out. The regulations are almost every question that can be sent to our office is the answer is in the regulations. While it's not easy to find, and I do know that it can It is, I am recording, Dusty, just to let you know. I remembered this time. So it does have the answers to almost any question that you can ask. And what I love about doing with the regulations now that they're online or in electronic format is that I would come to open it in a PDF format and say I was just wanting to do search on what was said about, say, vacation or whatever it might be. You could do a search within the PDF for keywords, or if you wanted to know something about credit cards, or if you wanted to know something about page rates, you just do a PDF search for keywords, and then it takes you right to the topic that you want to discuss. And so what I'm going to do today is kind of just walk through step by step. I'm not going to go through everything, but I have highlighted some things that I definitely wanted to point out. One of the things is contact information. If you ever forget who you need to contact for what, or if you needed a phone number, well, mostly know our phone numbers. If you needed, and this does need to be updated because we update it annually in July of each year. So we're at the end of that cycle where we haven't updated any changes that have happened in the last year. So the next thing, this should have most of the contacts that you would need for throughout the course of your employment. The one thing I did want to discuss is that the comptroller's office, they are a processor for court reporting services. So on occasion, somebody will call payroll and ask why they had a certain, why they were docked pay, or why they didn't receive this increase that they were supposed to get a step increase. The comptroller's office does not know that. They essentially pay you what we instruct them to pay you. And we instruct them to pay you what the chief judge instructs us to pay you. So like if we get an unpaid leave from your circuit, from your office, we process that unpaid leave. If you have a question about why you were docked on that, that goes to your circuit first because we pay you your salary unless told otherwise by your circuit. So in that sense, you get docked for something and it should say it was originally unpaid and you switched it out for a vacation and you shouldn't have been docked. You would never call the comptroller's office about that because they have no clue why you were docked. They would send you back to us, which isn't even correct, and then we would send you back to your circuit to correct it with your circuit. So just to give you an idea of how the comptroller's office works, there's rarely a reason why you would contact them directly unless it's something very specific to your deductions changed for some reason. I don't have your deduction information. They would be the ones that do that. So that's about the only thing that you would call them and ask them about. But typically it's best to even start with our office and make sure that you would contact the comptroller for something. JMIS, that is if you're having issues with ER. Not everyone has ER. The professional regulations phone number, that's for your licensing. If you have questions about disability or want to talk to someone about your pension, these are the numbers here. So all of these things and workers' comp hotlines. There's a whole lot of definitions in the regs of things that we talk about or we might throw around But for the most part, you know these things. The ones that I wanted to point out are an employer group, what that is. You are all in an employer group, and people commonly are like, what does employer group mean? If I send something out and says this applies to employer groups 2 and 3, or it applies to employer group 1, Cook County is 1. A lot of the collar counties surrounding Cook is group 2, and then the rest of the circuits are group 3. And that's it. So if you know which circuit you're in, you know which employer group you're in. Now, employer representatives. This is set by statute, and each employer group has a representative. And also the chairman of the Conference of Chief Judges, the 4th member of this executive committee of chief judges. So right now, if you're in Cook, your employer representative is, of course, Judge Evans. If you are in the 3rd downstate area, then it would be Judge Tedeschi in the 2nd Circuit. I gotta mute somebody who's not on mute. I gotta figure it out. Well, I'm gonna keep going because maybe Jerry, that's your microphone. You need to mute. Name popped up, and then so employer group 2 right now is Judge Shainstadt, and he is in Joliet. That, along with Judge Kramer, who is the conference chair, makes up the executive committee of chief judges. And essentially what they do is any decisions I can't make myself. Oh, I'm going to have to pause for a second to mute some people. Hold on. All right, I'm back. All righty. So we have, I have to remember where I was. So that's the executive committee. If there's a decision I can't make myself, it gets escalated up to executive committee. They kind of make the major decisions on behalf of all the chief judges, as long as all the chief judges do not have to weigh in on it. So for instance, if one of your circuits gets really busy with cases and you need an additional court reporter position, not that you just have a vacancy you want filled, but you need to add a person, that would be something your chief judge would send to me, and I would present it to the executive committee, and they would make that decision. Now, if it's something that would affect policy statewide, like a change to the regulations, that's going to go to all the chief judges at their meeting. They meet twice a year. It was in person, but June is going to be in a video conferencing, so we will still be meeting in June and making some decisions if there's anything that needs to be kind of finalized for statewide policies, and that's when they do the votes for all the chief judges. So the rest of these, I don't think there was much that I really needed to go over on those. Let's see. So the first section is really just going to talk about the titles and kind of the minimum standards of each of those titles and what's the difference between a 3 and a 4. Court reporting services supervisor titles that are set in the regulations, but then there's additional titles that are defined by the Court Reporters Act. So this isn't all inclusive of any position that would be named, but some are by statute. Proficiency examinations, most of you understand that. The one thing that I wanted to point out for the differences between computer proficiency and real time, for anyone who's new, they're essentially the same exact exam, except for this one thing. You can take the audio dictation, the audio that they play for the exam, turn in your real time. Then for the computer proficiency, you would have time to edit and then create a PDF file, and that would be the computer proficiency. So that you will get your edit time, and as long as you can, it's 96% accurate, that is the level 3 official court reporter. And then of course there's real time at 96% unedited. If you, we had to cancel all the exams that were for this spring, but as soon as we get a little more clearance to move around the state and things have opened up quite a bit more, Dusty will be in touch with supervisors and seeing if we can get those scheduled for later in the summer or the fall, but we have to kind of watch to see where things are going to know whether we are going to be able to, or when we are going to be able to do the exams. The next thing is that I wanted to point out is your chief judge is essentially your top boss here. I am on the same level as you guys as far as working for the chief judges, but I have 24 bosses instead of one. So essentially they have the authority to hire, to discipline, to discharge employees. That there's no authority my office has to do those things. So each of you, your job is decided on by your chief judge, and how the circuit is staffed and how the circuit is scheduled. That's all local, and it's not something that I have the ability to weigh in on, because ultimately your circuit is run by the chief judge. The other thing I wanted to point out is that you are not required to be an Illinois resident to be an employee of Court Reporting Services. Now, if there was two competing people for a position to fill a vacancy, then you would need to give precedence to the Illinois resident in that case. But we do have residents of the surrounding states. I'm pretty sure we have people who live in Iowa, Missouri, maybe Indiana border, Wisconsin. So it definitely is okay for that to happen, but in a competition between filling a position, they're going to have to go with the Illinois candidate first. So that was one thing I know that some people don't realize, that you do not have to live in Illinois to work for Court Reporting Services. Supervisors. One of the things that I wanted to also point out that is kind of people don't realize is that court reporting supervisors who are CSRs can go to court. Sometimes they do, sometimes they don't. It all depends on how busy the circuit is and whether that supervisor needs to go to court or not. Typically, the regs say emergency coverage, and as long as their supervisory duties are complete. I don't necessarily mean on a day-to-day function, but what we're saying is that if you're a supervisor and a court reporter, if you're going to court regularly and we're not getting the stuff we need from a supervisor, that is when there might be an issue with the completion of supervisory duties. So that is pretty much, as far as a supervisor goes, how that works if you have a CSR. Per diems, just to let you know that if you have a vacancy, an open vacancy where you're trying to hire an official court reporter, you can use a per diem court reporter in that position until a permanent is hired. So there's no further like extra approval needed by executive committee or the chief judges as a whole. If you have a vacancy, you can use a per diem. You can use several per diems in that one position. You just can't have them working at the same time. So it's one thing that can be a benefit to some circuits, that if you know some people that aren't ready to pull that trigger on being an official court reporter, but they might fill in here and there, having them be a per diem is kind of a great thing. So you can talk that up to any of your friends that are not working in the courts, and maybe we can lure them in to being official. Now, on the other side of that, there's probably some of you that are here, or some of you thinking about retiring soon, but you're wondering about being a per diem after you retire. If you retire and you're taking a pension, you can come back and be a per diem. There is no longer a cap on 75 days that there used to be, because what we have a new position for per diem that is a non-pension position, which means you're not paying into the pension system, so you are not jeopardizing your pension. You are also not adding to your pension service credits, but that's fine because you're already taking your pension. If somebody takes a per diem position with the state, not a retiree, they get to choose whether they want to be in the pensionable position or the non-pension position. What I would say is, like, if you're talking to a friend about coming on per diem, tell them to take the pension position, because they will start earning pension credits as a per diem. And if they decide to pull that trigger and become an official, that service time has already started for them. And they can count that towards their pension, and it, in the long run, will be better for them. So just to let you know the difference between those two pension per diem positions. So the next section I'm going to talk about is just general responsibilities of court reporting services employees. One of the things is not transacting, do transactions in the courtroom with the parties unless you need to do for that outside of the courtroom, in your office, things like that. This is very clear. You may and should interrupt proceedings when it's necessary to assure a complete and accurate record. This gives you permission to do that. Of course, questions should be directed at the court, not at a party to the case. And then this other thing is not displaying partiality, undue friendliness, trying to stay impartial in the courtroom, and not conveying your feelings about a case, about a person there, and maintaining that impartiality, keeper of the record. Another thing I know a lot of court reporters have questions about, because it feels like such a gray area, is confidential transcripts. For the most part, there are a lot of things that can be confidential, and those things should not be released to the public unless there's a court order telling you to do so. If you ever have questions about it, then you would go to the trial judge, your chief judge, things like that, and you would get an order to do something that you needed released. The other thing that court reporters get really concerned about is once a confidential transcript goes to the clerk's office. Once you file that transcript with them, it is not your responsibility of confidentiality at that point. You have been released from that confidentiality requirement, because you've handed that over to another clerk of the court. So I did see that there's a couple questions, and I'll go ahead and answer them. Annette wanted to know if Cook Counties will get per diems again. That's a local decision. It has nothing to do with our office, and I couldn't answer that question for you. That's a staffing issue. Marcia, missed something, don't do a transaction in the courtroom. I'm sure there are exceptions to it, you know, and where there's no other option, but for the most part, having business transactions in the courtroom is not something that they would want on a regular basis. So if it is something that is necessary, or if it's something that's routine locally and it's accepted, that's fine. I'm not saying that anything in these regulations or something, unless it says you could be terminated for it, it's not something that's going to be serious. But if you do have questions, I would talk to your chief judge about it. And this is kind of exactly the reason why I'm having this conversation about the regs, because there's little things in the regs that I may not realize is not realistic for a court reporter view. And there are things that court reporters might realize that aren't in the regulations. So if there's a conflict like this, like that's not realistic, it helps me to know that. But if it is realistic and it's that it can be avoided in some way, I would say avoid it. Now, if there's something that is just wrong, needs to consider being taken out of the regulations, that's something that I would present to the chief judges at the June meeting. So if you have things that pop up today that you're like, that's not realistic, let me know that, because I don't sit in, your spot every day. And realistically, do I think these things can be carried out how they're in the regulations? Most times, but not always. And so I need your feedback to know that something in the regulations may not be realistic in your world. So just let me know if something like that it kind of pops up and is seems like that's not realistic for you. So what I was saying about the transcripts, once they hit the clerk's office, no longer your responsibility. I know a lot of court reporters are like, I don't think that clerk understands that this is a confidential transcript and what they do with it. You can't worry about that because it's not on you. If something happens after you hand that over to the clerk's office, it's filed with the clerk. Even though it's your transcript, that confidentiality issue is no longer on you. If you have a question about confidentiality, it's a very specific case, I would talk to a judge or supervisor and get direction. Sometimes people call me with those questions and I can give you a general answer, but this is more specific to a case. So I would talk locally first on a confidentiality issue and just make sure that the local judge is on board with your perception of whether this is confidential or not confidential. The next thing is retention of notes and electronic recordings. There are two places that talk about retention of notes. One is the standards for the security of the official record, and that is available on our website. You can read through that document. Or the Certified Shorthand Reporters Act, from your licensing, there is a minimum time that you would keep it. I think it's all 10 years now from the time you took it. And that is longer than some of the things that are in the standards from AOIC. So whichever is greater is the one you're going to follow. The one thing that gets all convoluted is criminal felonies. Because if you read the convoluted description of when you can get rid of them, it is, you might as well be indefinite. So how we avoid keeping notes forever when you feel like, okay, this is appealed, it was 10 years ago, I don't necessarily feel like I need to keep this anymore. If you need to get rid of something or you want to get rid of something, I know everything's electronic now, so it's easier to keep as opposed to when it was paper. But if it's on ShareFile and you've verified all your stuff is on ShareFile, that's still considered keeping your notes of the proceeding. So whether you have it on paper, whether you have it electronically on somewhere, or whether it's uploaded to ShareFile or many of these, that's you retaining those notes. So that would be leading us to the next thing, the storage of notes in electronic files. You're essentially responsible for the safekeeping of anything you've taken and putting them in the right place. So whether that be you upload to ShareFile, this is like turning in your notes from your paper notes from way back when, and instead of storing them in a basement or attic at the courthouse, we're storing them on ShareFile. So possibly, I'm not as familiar with what Cook County does as far as turning in notes right now, but you always have to leave a copy of your notes with the court. So that being said, if you have old paper notes from forever ago and you have uploaded the electronic files to ShareFile, you can get rid of those paper notes and the county will probably love you for it. So it's the same thing, whether it's paper or whether it's electronic, it is considered stored if you either have it on ShareFile or it's in the courthouse. But as you know, a lot of those paper notes are now disintegrating and you can't read what's on them, or the paper is dry rotting because the conditions they're staying in are not very good. What you need to do, if you have notes that are unreadable, get rid of them, because storing them to just show them to someone one day if there's a request from it. There's just really, you could keep a log of what you got rid of if you know, but if there's paper notes that are illegible, just get rid of them. There's just no reason to keep them in the courthouse anymore. And I know everybody gets worried about that, but illegible notes aren't going to do you any service in the future, so you can let them go if you can't read them. Or older, court reporter notes of people who have left and they've been gone for 20 years. You can get rid of their notes if they're not unreadable, or if you can't read them. So the next step I'm going to talk about is kind of ShareFile. We started ShareFile in like 2014, so we've been going for about 6 years now, and anyone is able to do, everyone who is on staff with us, everyone who has been on staff with us, and per diems all have access to a ShareFile account. You can back up your notes there. It's unlimited storage. You have your own folder. If you don't have a ShareFile now for some reason and you want one, you can email Randy Lucas and ask her for one. So our office now, we all have our first name, and Randy would be RANDI@ilcrs.com. You can send her an email from the email account that you want ShareFile set up for, and she can set that up for you. And then you can back up all your things there. Cheryl asks, what affidavit would you do for that? For destroying notes? That is something that we have no guidelines for notes so whatever you would do locally, if you needed to do an affidavit for that, then you can prepare that on your own and put in it what you want. But as far as statewide requirements, there isn't a requirement for destroying notes. You don't have to request that. You don't have to request from our office to destroy those notes. It's essentially going to be on you. If someone were to come and look for a transcript from those notes, that you would put something in the file that would remind you or your someone who takes over your job in the future that those notes were destroyed because they were not legible. So that's completely up to you on what you put into that affidavit and how you would handle that. So Randy's last name, question that I received, her last name is Lucas, Lucas. Okay, so in ShareFile, what you would upload there, raw stenographic notes, dictionaries, translated files, completed transcripts, you're backing everything up. So everything that you may want to have access to in the future, you back it up there. The most important ones, though, are the raw stenographic notes and the completed transcripts. And why that is because if you save your backup to ShareFile in your software version, if you were not available or interested, like you've retired and took off and nobody can track you down because you went to Florida or Hawaii or something, and if someone had access to your files, then they would need the raw file in order to try to create a transcript, along with maybe a copy of your dictionary. The files that are saved that have been translated through the CAT system are only good for that CAT system, and you would have to bring it up through all the different versions in order to use that file. So if it was in Case Catalyst, or say it was in some version of software that 15 years from now no longer exists, we would not be able to get a transcript from that. And just if you're feeling weird about the idea of somebody else creating your transcript, nobody wants to create your transcript. It's not going to save anyone money if somebody else creates your transcript of something if nobody can find you anymore. So we are not interested in that. It's much harder. We want the court reporter who took the notes originally to transcribe that transcript, so, and have whatever income that comes from it at that time. So that the best thing to do is make sure that your stenographic notes, dictionaries, and completed transcripts are in there. But the translated files, those are for you. I do know there's been many instances where court reporters had backed up to ShareFile, but they had a hard drive crash. I would say since ShareFile inception, there has been at least a dozen reporters contact me because they're frantically looking for a file and they can't find it. And we have been able to pull it off ShareFile for them. ShareFile should not be your only backup. You should be backing up for yourself, and this is the state's backup of your records. So just to repeat, if you need a ShareFile account and you do not have one now, you would send an email to Randy Lucas, RANDI@ilcrs.com, from the email address you want registered to ShareFile. So at that point, she will set you up with an account, and then you'll be emailed an activation fee, or activation fee, not a fee, an activation email in order to start your account. And then it's essentially an online directory. It'll look like Dropbox or something like that, but the storage size is unlimited. It's a free service for you as an official to back up all your records and not have to pay an additional company to do that. And it is unlimited. So if you want to back up your audio sync along with your stuff, you can do that. So, because those files are really big, I wouldn't suggest, if you're catching up on some backups, that you would do a whole bunch at the same time. But just at this second, I was just, Cheryl, do you want to add anything? I know you're probably thinking something right now about ShareFile, but if you wanted to pop on and say anything, I would be more than happy to have you mention some things about ShareFile. Since I don't upload court reporter notes and I don't do your job, I don't know ShareFile from your perspective. So if there's anything you want to add, feel free to pop in. So the other thing about this is that if you are keeping stuff on removable media, whether that be diskettes, CDs, flash drives, I have seen some, those 5-inch floppy disks still when everybody was on DOS. If there's any way you can get those things onto ShareFile, because those removable media has a high probability of failure. Whether it's a DVD, a CD, a diskette, a flash drive, they go bad. Don't have your only copy of notes be on one of those things. External hard drives fail, internal hard drives fail. There's so many things that you don't want to mess with your notes. And so what I would say is you upload them to ShareFile, and even if you keep them on what other media you do, then go ahead and know that on ShareFile they are safe. They are backed up there. ShareFile can't have a hard drive crash, so you are ready to do that. And you can just keep everything there. And I'm going to go over to the chat window for some questions. Must we name ShareFile a certain way? If you would consider in your ShareFile that somebody else is looking for that file. So what I prefer to see in ShareFile, I think it's down here somewhere, is name it with the 4-digit year first, with the 2-digit month next. Because if I'm looking for some file that you think that was from a hearing in April 2005, and if you name your files April spelled out with an A, then I'm scrolling through all the Aprils to figure it out. I can't go right to the year, right to the 04. It's just an easier way to find things because they sort in chronological order that way. That being said, you don't have to name it a certain way, but if anyone else had to find your files one day down the road, they would be forever grateful if you named them in a way that the year was first and then the month was second, and then whatever you do after that is up to you. But a lot of people will put all their like 2019 files in one folder, and you can put all your that like that. If you don't have them that way, that's fine as well. But it's really nice for us if we're helping you find something that it is organized in some manner, and you're not just dumping your writer files into one folder, because that's a whole lot of files to scroll through. So that is one thing. If you can make directories, subdirectories to kind of organize your files, that would be great. And we can find things easier. So Crystal, I real-time in the courtroom, and that's what I've uploaded to share files. So you're saying all notes from SD cards need to be uploaded. I'm wondering if there's a quick way to do that. Carol, you want to talk about a quick way to uploading all notes from SD cards? It is definitely something that we need the raw notes for. So, oh, Cheryl, do I need to you can't unmute yourself because I put mute. Let me find you. Are you sure you can't unmute yourself? I thought Dusty talked. Let's see.
You should be able to unmute herself.
Okay, Cheryl's unmuted. Hello? Okay, well, we'll get back to you if Cheryl's not able to pop in and tell me. Lisa asks, is the Stenograph Cloud okay way to back up files? As far as for yourself, yes. As far as for the state, no. If Stenograph is offering a cloud service to back up your files, it's likely on a server that's being replicated and backed up on their end. So that would be a good way to back up your files for yourself. But for the state, you'll still need to do share file. That meets your requirement to store your notes on behalf of the state. So here in the regulations, just to make sure that everybody is very clear, the reporter that created the files will always retain the first right of transcription. So you have, the thing is, if you've left and you're not responding to transcript requests, you need to do that because they can't wait forever. At least reply and say, yes, I will do this, and start that conversation. But we have situations where court reporters have retired and they've moved out of state or something like that, and the supervisor keeps emailing them and letting them know that they do have a transcript request, and they are not able to, they don't respond. So the supervisor wants to know, can we move on? So that's why it's in here now. Like, you have 7 days to respond. I'm not saying 7 days to create the transcript. We're saying just reply back and let them know you're doing it or you're not doing it. So,
Tammy, I did put my mic in. I didn't have a microphone in.
Oh, okay. I was wondering where you are.
I'm here. On the share file thing, they need to put their SD cards in and back up the whole SD card. It'll go real quickly that way if they just take the whole SD card, put it into their computer, right-click copy, left-click paste to your desktop, and then upload. Name them however you want, the date range that's on that whole SD card, and then upload them to share file. Because if they're just real timing and doing those notes up to share file, 10 years from now, or if they change software, it's the exact same situation. You're not going to be able to get onto them. And the same thing someone had emailed me about, they were just uploading PDFs of transcripts that they had translated. That's absolutely totally not worth doing because you cannot edit a PDF. And once you've made it into a PDF, you cannot bring it back into Case Catalyst to edit it. So that is not a good method of storing to ShareFile. Okay, that's it.
Okay, thank you. And we do have a question on whether ShareFile is HIPAA compliant. I have not been asked that before, and I did a quick Google on it. They do have a lot of stuff about HIPAA compliance for healthcare organizations, so I will have to look into that. I do know Citrix is one of the largest companies as far as holding files for companies, and they work with very big companies, and I know that there are securities in place, but I have never specifically addressed what they would need to meet for HIPAA compliance. And I do see that they do have HIPAA compliance for healthcare organizations, and that's what's popping up when I did a quick Google search on it. But I will look into that and see if there's something else that court reporters should be concerned about as far as HIPAA compliance. Somebody had asked if right now in Cook County you're handing in CDs. You would need to discuss with your supervisor whether they would be okay with putting that on ShareFile in order to stop turning in CDs. That would be a local decision, and I don't know if there would be any union involvement with that decision. Like, I guess if you were wanting to do that I don't see why you couldn't, unless it still doesn't meet the Cook County requirement for CDs, because it is really kind of a local thing for you guys on your process. So I don't think that will satisfy that request at this point. But you're still welcome to back up your files to it. So I think that's a local conversation that needs to be had in Cook County, but I do think that you still need to turn in the CDs at this point because that's what their local procedure is. If that were to change, they would let you know that, but you still are more than welcome to have a ShareFile account. The next thing, real-time translation, court proceedings, CART. The one thing that I want to say about this is that everybody has a differing opinion, but the one opinion that I hold strongly about it is that, well, first of all, I'm going to start with this, not the CART. You're not required to be real-time certified to provide real-time, although it is highly recommended that you have gotten that certification if you're providing it. But you're real-timing whether you're certified anyways, so it's not like since you haven't attained the CRR or level 4 that you can't provide real time. You can still do that, depending on who you're providing it for. Somebody had asked at the last seminar, so if you weren't at my session where I talked about this, if you are providing real time to a party, you can charge them a page rate for that. What would happen in that situation is but you would have to give them the rough draft text file. And so that's how we get around that loophole for right now, that you couldn't take a real-time fee, but technically you can, and it's by page, and you can charge $4 a page for real-time as long as you give them the rough draft when you're done. So it's essentially you're selling the rough draft to them. And also that if you can also decline that. So if you are not comfortable with providing a rough draft and having that leave your possession, you're not required to give someone a rough draft if they want it. So we're leaving this as flexible for reporter friendly. No, it is not daily copy if you give them a rough unedited text file, because it is not a certified copy. Now, if they want a certified copy after that and they have this rough draft, they have to pay $4 a page again because they have never got the transcript. This is just the fee for the unedited, uncertified copy. So now if they want daily copy, like cleaned up, certified transcript, yes, that would be daily copy rate. But if they want a real-time feed during the proceeding, you can get paid for it by charging them $4 a page. Does everyone understand the differences on the nuances? It's kind of, one is a feed, the real-time feed, and you charge them $4 a page. You can charge them $4 a page for that as long as you give them the rough copy. Now, if they want daily copy, you're going to clean that up and give them a certified copy, and that would be daily copy rate. A week down the road, they want the certified transcript, and they ordered the real-time feed during the case, and you gave them the rough unedited. You could still charge them $4 because now you're giving them a certified transcript, and this is the first transcript request that they have. So there are two different things going on here. One is real time at a page rate consistent with regular delivery of transcripts. So that's why it's $4 and not daily copy, because they're completely different. Let's see. Yeah, they can't be used for verbatim citations. So now we're getting into CART providing, and this is a local decision on whether court reporters are used as CART providers or whether you're used to real time for hearing impaired in certain case situations. While it is our offices and a general idea that officials should not be used for CART, we do know that in some cases it's just unavoidable. It's either not available, the county is not paying for it, or whatever that's going on. So this policy is flexible enough that we have every kind of situation that would happen when an official court reporter is being used to provide CART. If they are being used, we hope that they're providing real time and they'll still get transcripts from that, but we do know in certain situations that they aren't providing a real-time record, or they are providing a CART record and not real-time, and in that case, a second official would need to be brought in. So we've seen the whole gamut of assisting the hearing impaired, or whatever reason somebody is providing CART to meet an ADA requirement. In that sense, we do spell out here that breaks are very needed and they're mandatory. And whether judges put a lot of weight in what it says in the regulations, this is at least something that you can use to remind them that you need a break. You need to be given a time to step away from your writer if you've been providing real time. So transcripts generally, let's see. On the chat, we only provide CART and other reporter gets the order, not us. I wish ideally that wasn't how it worked in some circuits, but I do realize that is how it works. There's nothing I can do about that, because if we go back to that beginning, the chief judge and the local administration, they have to make those choices on how court reporters are assigned. And in that sense, when the county is working with the chief judge's office on providing these services, then that's how it gets provided. Cook County is not alone in that. There are several counties that do something very similar. I don't personally like it, but I'm not the one who's running the circuit, and a whole lot of things that's really above my pay grade, unfortunately. So in the next section, we talk about transcripts. You're not required to file a copy of the transcript with the case file if the person is requesting it from you directly. I do know some circuits have some local procedures that might be more stringent than this. So if your circuit does something different, then that is your chief judge's prerogative. transcripts filed with the clerk of the court becomes a part of the public record. They may be reproduced without additional fee payable to court reporting services employee. I know we all hate this provision as well. And it's been an ongoing problem, but by statute, once it becomes public record, they don't have to purchase a copy from you. We know as we get into more of a digital world and we're not paper anymore, this is getting easier and easier to do. But many clerks have a professional courtesy relationship with the court reporters, and they will send that request back to the court reporter to provide, but not all of them do. I would say that the only way we can avoid this is that in the future we set copy rates of things that have been filed with the clerk at a lower rate than what you could get them from the clerk in order to undercut that cost of the person trying to get a copy of the transcript. And that's something that we have been looking at in saying that, yeah, if something has been publicly filed, the copy rate's going to end up being X, which is just below what a clerk would charge them, just to make sure that they are going back to the court reporter to get that. And in that sense, you can already do that now. You don't have to charge them 50 cents a page or $1 a page for a copy. You can essentially undercut the clerk at any time if you know people are going to the clerk's office. You can always charge less than the page rate. You can never charge more than the page rate than what's allowed. So that's a good way to be a little sneaky and try to undercut something. If people are selling transcripts out of the clerk's office, I would just make it publicly known that they can get them from you for less. So the next is transcript fees. The one thing I wanted to point out was the premium for expedited. So except for transcripts ordered by the state. So the state for indigent defendants, we will never pay expedited or daily copy. That is just set up in our provisions. And the county, each circuit decides whether they will pay expedited rates. Some counties do, some counties do not. And we're not going to set that by the state or tell the county what they can or cannot pay. So it gives them a provision. They have their own policy about whether they pay expedited or not. The next one I X'd out because since we last did this, we do not do paper vouchers anymore. So I need to update that to reflect CTF that has come out in the last year. Pointing out that abused, neglected, dependent juveniles, those appeals, they are paid for by the general fund of the county. This is not a state transcript. We occasionally get JA cases or juvenile abuse cases that are filed into CTF, and the state does not pay for those. So if you think of it's almost every case, it's people versus, that's what the state pays for. There is a situation of the one MR case for sexually violent persons that we pay for, and then appeals and mental health cases. Those are the only two that wouldn't be people versus that the state pays for. Question, what is the rule for another copy of a transcript 6 months later? If it's the same person who wants the same transcript, they get a copy rate no matter how long has passed. If it's the opposing party, you've informed them that you are preparing it for one side, you can charge them an original. If it's something that was filed in the clerk's office, so I guess I need to know who's requesting it 6 months later, because the answer changes about that transcript depending on the circumstances. So if you have a specific circumstance in mind for 6 months later, shoot that into the chat window and I can answer that. So the application of the transcript page rates. So the indigent defendant copy is always provided without charge, Rule 607, and that is why now we have bumped the page rates up to $4 a page, and it is considered when you're filing with the state for appeal, it is just the original rate. Now, if you charge the original rate, a long time ago before we were doing electronic copies or electronic filing, and now they want you to e-file it, we can pay the copy rate for that because it's two different things. Like you didn't e-file it before, but now you're required to e-file. That we can provide a copy on for the state. But if you e-filed it, it should be in the case file. So that's why we don't pay for it again if something else were to come along and that transcript is needed again. So the state won't pay for it twice. It's just e-filed once. And the defendant's copy. So that's another thing. So we're talking multiple defendants here. So you e-filed it on case 1 and case 2 appeals later, you do get the 50 cents for that because you've already done the transcript. You get the 50 cents for e-filing another copy. Only if you're e-filing another copy. So it's really for the e-filing, not for the transcript. So there's a whole bunch of different situations. If you ever come into a weird one, just contact our office because I really can't go through every situation where there's an exception to the rule because there are really weird ways that people process when you get into 3 co-defendants and these 2 are together and this one's separate and this one has the same attorney and this one doesn't. But we don't pay for the defendant's copy. So it's only for the ones going in the case file. So if you keep that straight on what the state pays for, sometimes we get something through saying the defendant requested a copy and we're being billed for it. We can't pay for that. We don't pay for the defendant's copy because of the Supreme Court rule. Marcia, copy buyer in January wants to buy another copy in June. Okay, that's what I'm saying. So if somebody buys a transcript from you, no matter how much time has passed, if that same person buys the same transcript from you, it's a copy rate always. And that is in the regs leader. So as long as you asked opposing counsel, if they wanted a copy, if they said no, and the time goes by for the copy rate for that, then they can pay the original on down the line as long as you inform them. This is why we say get stuff in writing, email them, cover yourself that you did in fact let them know that that you offered that the transcript to opposing counsel and they did not reply or they declined or whatever that is. So when they come back a month from now and say, oh, we want a copy now, and you send them the bill for $4 a page and they want to fight that, I mean, you don't have to send them the bill for $4 a page. So it's just what you decide, but it is not improper to. So that's what I'm saying. So the time limit that, not state copy turning to original. Okay, you need to put more words in there because I might not understand what your question is. We cannot charge for the defendant's paper copy. Okay. All defendants are entitled to their very own paper copy of the transcript. Yes. And that is why the page rate is $4 a page now, as opposed to $3 plus 50 cents that it was prior to going to this new process. So essentially, if you compare it to what we used to pay for indigent defendants, you're getting an original +2 for each transcript, but it's now just all chunked into $4 as opposed to breaking it out into original at $3 and 50 cents for the defendant's copy. So that is why when we bumped it up to $4 a page, we had that in mind that you're not being paid for the defendant's copy. So we upped what you were being paid for the defendant's copy and just lumping it together. But we can charge for the e-filed SAD transcript. We cannot charge for the, okay, I went over that, I think, already. But it's only 50 cents if the defendant has multiple cases. Yes, at that point, after you did the original and got paid $4 for it, 50 cents a page because it's for the e-filing. How much time has to pass on charging the original again? If you go up here, a second and subsequent transcript of the same proceedings are considered copies and shall be charged at the copy rate, provided they are ordered by a party within 7 days following the notification that you provided them. That's why I said get it in writing that you've notified them, because after 7 days you are allowed to charge the original. You don't have to charge the original. If they come in day 8 and then they order it while you are allowed to, I would probably, I would probably want to lean on the side of providing them a copy because they're like 24 hours off. But technically, you are not going against the regulations by charging an original again. See, if a defendant has a private attorney and his attorney ordered the original, and the same defendant hires a different attorney, let's say a year later, can we still charge the new attorney the original rate if he can't get a copy of the transcript from the first attorney? The new attorney, gosh, there's a lot going on in that one. Technically, I would say that there's a lot of gray area in that one. Same defendant, different attorney. Whether you would charge the original or copy on that one, I would say on the same as the other thing, it would probably not be improper for you to charge the original rate again. However, people may charge the copy rate in the case that it has been prepared already and you're sending them a copy of it, same defendant. A lot of gray area on which way you go. I don't think either way would be improper on that, unless somebody has something else to chime in, but I don't think that either way that you would get in trouble for recharging the original a year later when the defendant has switched attorneys and you have to provide them the full transcript again. Okay, this is what I was talking about earlier. The transcript ordered by a party, they shall not be charged an additional copy unless they request it. So if a party contacts you and says, I want a copy of a transcript either filed in the case file or they want it in their hand, you can't go ahead and charge them an original in one if they're not asking you to do both. So if they're asking you to file it, but they don't want a paper copy, you can't charge them an original in one. If they're asking it for in their hands and they're not asking you to file it, that's just the original. Now, if they're asking you to do it both, then original in one. But you don't, if they want it in their hand, you are not, and this is mostly in private, probably civil cases, you can't automatically file it in the case file and charge them if they did not request that copy to go there. There might be circuits that are doing something a little different. So, but that is not the intent of this, is that you should be providing what the people request. If there's a local rule that overrides this, that might be the case, but it would be need to be by local rule. And way back from the hangover of days of where you had an original and a copy, literally meaning you had the original that you typed on a typewriter and then the carbon copies, we have gotten into terminology of original and copy, but we also have charging original and copies. It's all paper now, they all look the same. So, but we do verify that a certified copy is always considered an original in the case file, no matter how many, if you've already printed it 7 times, the one that's going in the case file is considered an original for the case file. And this next line is about court reporting services employees shall not take back a transcript that's been out of your possession to file on behalf of an attorney. So for instance, the attorney bought paper, and this doesn't really apply much anymore that we've gone into kind of digital. Say they have bought paper and you handed it to them, and now they want to file that one that they bought as the one in the case file. Well, since we're e-filing now, that's not as much of a concern, but a court reporting services employee could not take that paper transcript back and file it on their behalf. Now, if a clerk accepts that paper transcript directly from the attorney, that is between the clerk and the attorney. And if the clerk accepts it, you can't really stop it. So even though it's not how it's intended to go, there will be attorneys that do that. And on a civil case, if the clerk accepts that paper transcript and scans it to e-file it, then that is acceptable. The question, you cannot ask a government agency for a deposit according to the rules and regs. Are we allowed to COD a government agency? If it's a state agency, you'll never get a cash on delivery because it has to go through the process of the payment invoice processing. Now, if it's a municipality, if it's something else, I would have to look into that to see specifically how the wording is on it. I do know for any state entity, that's not going to work because we have a process that we have to go through to pay any bill. But I can take a look at that if it's like a municipality or a school or something like that, if that fits the all the statutory or Supreme Court rule guidelines that might dictate where we get this information from. So I'll take a look at that and see, but definitely not for the state. You cannot do a cash on delivery for them. So we are getting into the depositor transcripts, and you can okay, well, here's some wording. Except where the transcript is ordered by the state or any of its political subdivisions. So I would have to look into the definition of political subdivisions. So that's why I was saying for the state, you cannot request a deposit. You're not going to be able to get a cash on delivery from them. But for everything else, you can require a deposit up to the estimated total fee of the transcript. So you're going to want to advise the attorneys immediately about what that would be, so you can proceed, get your deposit and proceed with your transcript request. So monthly report of transcripts on order. This is the one thing that I wanted to point about this. It's as required by the chief judge. If your chief judge is not requiring the monthly report of transcripts on order, some circuits do not do them, some circuits do. That is a local decision. Although it does say you shall do it, but only as required by the chief judge. Certification of transcripts, I think you all are pretty familiar with that. The ER certification, the difference is to the best of my ability. Just to point out, the format of transcripts by the regs, it's here, 24 lines, margin sizes. There's the form book on our website that you can look for certain specific things that are outlined that are not here in the format. And there's some suggestions on how you do certain things. Index page should not be required if there are no witnesses or exhibits within the transcripts. And then here, if you're still doing printed formats for anything, they're bound in 250 pages. That 250 does not apply to electronic files, so you don't have to cut them up into 250 page sections. So keyword indexes, if you provide one for somebody, make sure the request is in writing, and you may charge a page rate for the index, but you have to eliminate common words in order to keep the fees reasonable for that service. So you want to take off the uhs and ands and thes and all the connector words, so we don't need an index of where those words were said. And I think most software does that automatically, or has a function where you can take those out. Make sure it's in writing. That's just a cover your butt thing that I tend to, anything you're doing for someone, the more that's in writing, the better. And then anything filed with the clerk of the circuit court now that we're in e-filing, just wanted to point out, it cannot be password protected in any manner. It's becoming public record once it gets filed. So that's it, there should be no password protection on public records. Transcripts in electronic format. You can use an embedded digital signature or electronic signature, and those, even the ones that you send out to people by email. I think that's pretty well known right now. Time for filing transcripts. The only different thing on appeals is 311. You know, that's the child custody issues, and they have a shorter time frame. So this, when you need more time, the request is in an affidavit or an affidavit accompanied by something showing why you need that extra length of time to do that. Appeals, civil are based on Supreme Court Rule 323, criminal are based on Supreme Court Rule 608A. You can look those up for yourself if you want more on what those things say. Transcript excerpts. So we require a minimum excerpt, and this is really to protect you. We had gotten into situations as more electronic things happen that people are like, can you get me the answer to the witness on that third question where somebody asked this? No, we are not doing that. So these are the regulations that protect you and set a minimum transcript excerpt, whether it be a full portion, a full section, how you define that might be, you know, the witness, can I have the witness direct examination? The other thing it's for, or the entire morning or the entire afternoon. Those are the smallest chunks you should be providing. So this is just to make sure, additionally, that you're not searching to do these one-line transcripts, but also to make sure that things are not out of context when you provide them to people. So everything around that question and answer should also be provided. Question popping up. Is it legal to use electronic signature on a hard copy transcript that is not an appeal or e-filed? For example, state orders a transcript. Yes, you are allowed to use electronic signatures. They are accepted on banking documents. They are accepted on pretty much everything, even if you print them. However, the one caveat is if somebody requests you to have the pen and ink signature in a certification page, you should provide them that upon request. So yes, you can print a paper with an e-signature on it, but if they request that you provide an additional certification, a matching certification with a signature that is an original, I would provide that for them. But for the most part, people have accepted e-signatures. They're used in all of they're being e-filed for public record. So to be held to a higher standard on paper, I don't think you need to do that. But in the instance, if somebody requests it, I would go ahead and provide that. The next section is about credit cards. And if you attended our webinar about taking credit cards and using Wave invoicing and tracking all your income and expenses with that software, then you'll know that we went over credit card payments, and this is where you find the fee calculator. So if you didn't watch that session and you want to know about sending people invoices by email, then it's on our YouTube page, and you can watch that. We put it up there. And let's see, my web page is going crazy here for a second. Okay, my screen sharing is paused. 1 second, technical difficulty. Things are popping up here. My goodness. I have no idea why all my email is popping up. But Okay, so I'm going to talk for a bit, and I know you can only see a paused screen right now, I believe, but I'm trying.
Tammy, I can still see you.
My screen, it was locked,
Okay.
so it wouldn't move. Okay, it's back. Okay, financial disclosures, as you may know, I'm going to speed up a little bit because I have like 10 minutes left. They're due by May 1st of each year. We have extended it this year, August. We'll talk about it. Don't worry about it right now because that's the last thing that we need to think about. Even though the deadline is May 1st, they're accepted up to June 15th in a normal year without sanctions. So we're still not even there yet, but we have extended the deadline to August 1st, and then the sanctions wouldn't kick in until like September 15th, but we'll work through that. You can also file your annual financial disclosure on WebHR now. So there is a form on there where you can just fill that out and submit your information there. I'm trying to work out some kinks on making sure your supervisors get them so they can approve them, but not sure if that would work. So if you have a complaint filed against your license, you're required to notify your chief judge's office. Section 3. Okay, just wanted to point out that there's additional deductions that you can have taken out of your paycheck if you want. Deferred compensation, dependent care, flexible spending, direct deposits. We highly recommend those, especially in the mail these days. Travel reimbursement, if you get it. You can go here to read the governor's travel guidelines. Any travel between the residence and your headquarters or any portion of that is not reimbursable. And this is mostly applicable for people who do not live and work in the same city. So if you live in one city and you work in another, you have to pay attention to your travel route to decide, like if you go through your headquarters, you can only bill headquarters to your temporary location. If you don't go through your headquarters and you head the other way, you can voucher the whole way. But if you ever have questions, if you don't live and work in the same city, touch base with Randy. She processes our travel vouchers before you send that in, just so we don't have to return it to you since they're still on paper, and I don't want to delay transcript travel voucher payments. A question, is Cook County using WebHR yet? You are using it in the sense your leave is being entered in there, and you're using it in the sense that any Cook County employee may log in and see your current balances, but you are not submitting leave requests through WebHR at this time. So yes and no. You are using it to be able to check your leave balances, and we are getting HR used to entering leave that way through the WebHR system. So if you have discrepancies on leave you have taken and leave that that has been approved, it should be showing your time now. I don't know where they are caught up to. So if there's something very recent, you may not see that yet, but you can see everything. You can, if you logged into your WebHR and went to your leave page, it will show you everything that's been entered in the system for you, every date. So if you notice something is missing or something is entered and shouldn't have been, then that is something that you can verify with your supervisor that your attendance is correct. Let's see, so going through a few more things here. This is all about travel, accident reporting. These are things you won't use regularly in day-to-day function of your work, but they are in here. Photo ID cards, we provide them to all employees. If you have a change in your personal data, there is a page on our website that has all the links to the forms and places that you need to change your name or address. I've often joked that if you saw the number of forms you have to fill out, that you would just not move, because it's a little ridiculous, all the different agencies that need to know that you have moved. On-call policy, why I have this asterisk is that it actually shouldn't be in this section. So on-call policy, should be moved into section 4, which might be different whether you're union or non-union. So this section will be moved in the next version of the regs. Dress code, essentially be reasonable and listen to local dress codes. Performance evaluations, the one thing that I wanted to point out is they should not be forwarded to court reporting services. Those are local things. We don't need to see your performance evaluations. That is between you and your circuit or county. Inclement weather, work sites are closed. If they are officially closed by the chief judge or the presiding judge, you do not need to use your own time. There is a question about looking through the regs, and I don't see that we cannot work in the reporting field after working hours. Is there such a restriction for an employer or supervisor? Here it is. Private reporting work is prohibited. There's a lot of, this is in way before my time with the AOIC or with court reporting services. The one thing that I could glean out of this, why it was done, was because there's a lot of blurred lines here. There's conflicts of interest and workers' compensation claims. So there's a lot of very separate reasons for why this is like this, but there's really no hard and fast reason that I would be able to say to you why their private reporting work is prohibited. I said the number one thing is workers' comp claims that we've had through the years, and trying to delineate, is that self-employment, what part is independent contractor, what part is a state employee, and should the state be liable for your full workers' comp claim when you in fact have two jobs as a court reporter. So there's so many blurred lines that the chief judges have not wanted to touch this as far as part-time work so in the court reporting field. So in the next thing is kind of, with permission of the chief judge, you can provide closed captioning or real-time translation of meetings of governmental departments outside of your normal working hours for hearing impaired. What this is like, we've had court reporters who are asked to do closed captioning for, say, a county board meeting or something like that, where you can provide that to a governmental agency. You can charge an appearance fee, but you have to notify your circuit what that fee is and that you're doing it. So it's kind of a part-time thing. So as long as you're still serving governmental entities and you're not having issues where your supervisor or chief judge doesn't have objections to it, you can do that type of work outside of normal working hours. And nothing in here prohibits you from volunteering to do captioning for hearing impaired. So when this first came out, people were saying, does that mean I can't, or when we added some of this language at some point, people, oh no, actually the history of it is that real time became a lot more common, and people were reading this very altruistically and very fine line and saying, does that mean I can't caption for my church on Sundays because it's private reporting? No, it doesn't. If you're not being paid for it and you're captioning as a volunteer, there is nothing that says it's private reporting. You're volunteering, so you're not being employed as a private reporter. And secondary non-reporting employment, you can do that as long as there's no actual or potential conflicts of interest. Your circuit knows that you're doing that. You're not using state facilities, and that it's not interfering with your official duties. And that's pretty much it. You need to notify them. That is something that would go on your annual financial disclosure as outside activities, what you earn. It's something that takes your time. So if you're being paid an hourly wage for something outside of normal working hours, that's something you're going to disclose on your annual financial disclosure. That's stuff that doesn't take your time, like dividends or child support or alimony, things like that. We don't want to know that. That's private to you. We don't need to know that. But if something is taking your time outside of work, that's something that needs to be disclosed on the annual financial disclosure form, just to make sure there's no conflicts of interest. We've had people calling themselves court reporters and just using recording devices in our courtrooms. In the courtrooms, if someone's bringing a recording device into a courtroom, they are in violation of Supreme Court rules. So I would want to know more information about that. Now, they can do it in the, they can do it in depositions, but if they, okay, well, that's a problem. So I wasn't aware of that. I'm going to write that down for a second. But no, nobody can record court proceedings if they are not approved and certified by the Supreme Court, and that should not be allowed. That's a big no-no. So I can touch base and see what's going on there. I need to gather more information. Political activities. The one thing I want you to know is that the clear stuff is don't become a candidate, don't solicit funds, don't publicly endorse or oppose a candidate for public office. This is for the impartiality. If there's the fine line things, can you attend a fundraiser? Can you do this? Can you do that? If your name doesn't get printed in anything, you have the right to attend a fundraiser to find out more about candidates. You should not be listed as a major donor for that fundraiser in a brochure. So that's the difference between these things. If you have any question about which is right or wrong, go locally, because ultimately your chief judge is going to determine whether you violated this political activities policy, not our office. So bottom line, if it's okay with your chief judge, it's okay with us. If it's not okay with your chief judge, then it's not okay with us. So drug-free workplace, don't do drugs at work, don't drink at work, don't sell drugs at work. If you get convicted of drug statute during work, you need to tell your chief judge. That's pretty basic. Sexual harassment policy. We're actually reviewing this. As many of you know, there's a lot of requirements for state employees and for your license that are going to cover that you're going to need so many hours of sexual harassment training each year. So please, this policy is going to change, but the things that I would like to point out is that you have the right to a work environment that's free of sexual harassment. There's a lot of things that describe what sexual harassment is here. And then the other thing I wanted to point out is reporting. There should be an administrative rule or local policy which outlines the protocol when the complaint is by the chief judge, or what is your local protocol for complaining about judicial supervisory personnel. That goes to your chief judge's office. If it is the chief judge, your circuit should have a rule that has what happens in your circuit if the complaint is against the chief judge. So don't take any gifts. If you get some kind of like civil award or something like that, try to make sure it's less than $50 or give it back. This is the impartiality thing. Every judicial branch employee has to follow this. Employee assistance program. If you have any of these issues, this is any employee. There's a hotline to call for abuse issues, marital problems, depression, aging parents. It's the mental health line. If you are having issues right now, and I know a lot of people are with a lot of the shutdowns and the extra stress and the change in our lives, there is somebody available to answer the phone 24 hours a day, calling that hotline that is in your regulations. Please do reach out if you are having a hard time right now. Last section is, this is employment policies for non-union employees, but there were a couple of things that applies to everyone that I would like to address. And it may take a second for me to get to it. Okay, so I outlined the vacation policy because we don't get the set number of days each month. It's by a very strange schedule that was adopted from the Supreme Court. The one thing I did want to address is you are on a transition year. Say in July, you're going to go from 22 days to 25 days, but you're getting all of these days at the beginning of this last partial 22-day year. If you're hit a transition year in July, and this is your transition year, you don't get 25 days. You are on this schedule, the 22-day schedule for the first 6 months, and then you're going to be on the 25-day schedule for the last 6 months. So you have to add these days up together. You don't just automatically go to 25 days if your transition is later in the year. So that was one of the things that I wanted to talk about. The transition year, yes, that's one of the things that's pretty highly misunderstood on how your vacation is awarded in a transition year. It's split between 2 awarding amounts. Personal leave, thing I want to remind everybody, that the leave you can't carry over, so please use it before the end of the year. I don't want people to lose their personal time. I just wanted to point out is outlined here, and that is a federal policy, so it's the same for union or non-union. The one thing I wanted to point out, this is not a paid leave benefit. You only are in paid leave if you're only in paid leave if you're using your paid leave that you have earned. So it's just a guarantee that your job will be there if you meet FMLA status, whether you're taking paid time or unpaid time. Question, who is making sure you're getting what you're supposed to be awarded on a transition year, or is it computer generated? Between our office, your supervisor, and you being aware of what your information is, we do send out transition year reports to the supervisors each year, so they are aware of that, and that is tracked by database right now. But you also should be aware of when your transition years are, because stuff does get missed for whatever reason. On occasion, we miss step increases, not often, but these are things that you should be aware of what your time frame is. Like, when is my next step increase? And how you would know that is by, knowing when you hit that service credit time. And being aware of that. So you should be tracking your own leave balances, but at the beginning of the year on WebHR, it will show you what your balances are for the year. If something has increased and you didn't realize it was a transition year, then be aware that you might want to look into why it is, or if you thought it should have increased and it didn't, then that's something you would look into and ask a question. I thought I was on a transition year. Why didn't I get more vacation? And one of the big things is you, sorry, I keep reading the chat and then I lose my mind. So you're going to want to be aware of your own situation and when you bump up to a transition year, but we do send your supervisors transition year information. Jury duty, you can remain in paid status as long as you give us your jury payment check. You can keep stuff that covers mileage or parking reimbursement. So what you would do is make a copy of your jury reimbursement check that has the detailed out what you're subtracting, and then send us a personal check for the difference. That's how you would do that. Now, if it's non-work related, you have to take time off in order to do a non-work litigation. Anything else, if you're subpoenaed for your work, use workshops. We want you to go to these because they have a whole lot of information that's more personal to you and where you're at in retirement. Every 5 years you can attend without using paid leave time. You must receive approval to attend, and here's the website to register. It's in the regs. So that's kind of the end of the regulations. And the next question, do you have to use your time when on jury duty? No, you do not have to. There is a jury leave. That isn't, you get jury leave as long as you return the check, you get paid for jury duty, which is like $10 a day or something like that. You do not have to use your own time. If you want to keep that check, you do have to use your own time. Uniform schedule of charges. This is where the page rates are in the back of the regs. you're entitled to a copy. Daily copy is delivered within 24 hours of the proceeding, must be approved by the judge. Why that's in there is not because we want the judge to control the daily copy. We want to make sure that you have, if you are unable, like say if you're in a place where you're the only court reporter, so we're so different across the state, we want that request to go through the trial judge and for them to work with you to see if that's even possible to provide daily copy, or scheduling enough reporters to do daily copy. So that's why we don't necessarily want daily copy delivered within 24 hours to not go through the judge, especially. It's a protection for the court reporters if you're not able to provide it. For whatever reason, you can say, oh, that needs to go to the chief judge, or that needs to go to the trial judge to request that. And it can be declined if you just don't have the resources to do it. Going through here, there is not a whole lot of attachments that I want to go over. I have these X'd out because we're using WebHR now, and these will not be in the next version of the regs. They're overtime worksheets and things like that. Our salary tables are in the regs. These are actually outdated. They haven't been updated since 2017, and salaries have been adjusted since then. The new ones will be in the next version. The thing I do want to point out is that this is non-union. There's a tier for hiring, and then there's a tiers for years of actual service with the state. These are very different tables. Cook County has one table, and it's for hiring and years of service with the state. So freelance credits do not count for years of service. County service as a court reporter can count here. Per diem service can count here, but freelance time does not count at this point for service stats because it's not state of Illinois service. Here are some things about how simultaneous appeals and separated appeals for indigent defendants could be billed. Those are in the back of the regs. And this is a table in the back of the regs back when we had transcript codes. But this is every reason why the state would pay for a transcript and the statutory backing for it. So if you want to read further details, this is just a synopsis of why we pay for it and what guidelines and authority we have to pay for it. And then finally, there's the code of conduct. Everyone should read this if you haven't read it yet. It goes into more detail about things that are in the regulations on certain things, but yeah, you can't give legal advice. Be very careful of that. Confidentiality, it describes a little bit more of that. Improper use of your position, different things like that, and then conflicts of interest, all these things that you should not do. It's only 7 pages. Make sure you read it. It's on our website. The new regulations will come out after the chief judge's meeting, which will be mid-June, where they vote on any changes to the regulations, and those will be posted to our website, and any changes would be effective July 1. Okay, so I'm only a little over time. And if anybody has any questions, I would certainly take those. And if you have questions, you can also email me. You know, I have an open email box on questions that you don't want to ask here. Tammy@ilcrs.com. Go ahead and send me your questions. Obviously, I keep things confidential. Anyone who's asked me a question, you know that. I won't rat you out if you have a weird question. So just feel free to send me a question if you have any follow-up on anything that was here. And I appreciate you all attending this very boring topic for you. So take care, stay safe. I will announce the next webinar very soon. Thank you all. Have a good day. Hold on. Hold on.